I'm delighted to introduce Elizabeth Jennings, an associate attorney at Northwest Elder Law Group. Elizabeth received her bachelor's degree from Clemson University and her law degree from Boston College. With that, I'm going to go ahead and hand it over to Elizabeth, and she's going to take it from here.
Hello. So hello, everyone. Thank you for joining. Like many of you, I am working from home these days. So I apologize you don't get the wonderful office background, but I'm excited to talk to you today about estate planning, which not a lot of people think estate planning, that's exciting, that's fun, but I'm kind of strange like that. I am a planner by nature, so I'm really passionate about talking about estate planning, the steps you can take now to hopefully alleviate conflict or issues in the future. So I do have some slides that I want to go through. There's a lot to cover, and so I'm just going to touch on a lot of these topics. In addition to my full-time practice at Northwest Elder Law Group, I also teach a wills, trusts, and estate class at Edmonds Community College, and we cover all these concepts, you know, over the course of a quarter. So I'm going to try to touch on the big topics that everyone should be aware of, but of course, everyone's situation is a little bit different. So feel free to follow up with me if you have questions. Reach out to Era Living and they can direct you to me as well. So when I think about estate planning, I think about three big categories. The first, probably what most people think of when it comes to estate planning, is planning for death. How do we handle our affairs once we passed away? How do we make the process easy, or as easy as it can be with our loved ones? Planning for incapacity. So if there becomes a period, whether it's temporary or permanent, that you're unable to manage your own affairs or make your own decisions, have you planned in advance for who you trust to make those decisions in your place? And then the more fun aspect of planning to live a long time, right? How do we enjoy retirement? How do we enjoy our time with also consideration to possible increased care costs, increased financial needs? So I'm going to touch on all of these throughout our time here together. Like I said, I'm just going to scratch the surface. But along the way, if you have questions, feel free to add them into the chat. I'll try to address them as we go, and then also at the end for anything I didn't catch along the way. So planning for death, exactly what you want to talk about on a beautiful afternoon. But I think about planning for this process as something that you can do, a gift you can give to your loved ones to make the process easier on them, and so that all of your affairs are handled as easily as possible. So in this section, I want to talk about some of the most common estate planning tools that probably apply to about 99% of people. There are definitely other means for passing on assets or wealth at death, but I really want to focus on those that you may already have kind of in your file that you've done estate planning previously, or if you don't have these, think about, do I need to put one of these documents in place? So before I get into all the individual documents, estate planning simply means, how do we pass on our wealth or our estate when we pass away? And that can mean providing for family members, a spouse, children, grandchildren. It can mean providing for charities or causes that are, you're passionate about, and even maintaining control after you've passed away. So sometimes I get clients that say, I really want to provide for my grandson, but he's not very responsible. How do I control some of his decisions and how he handles those assets down the road when I'm not here? So good estate planning can help you address all of those issues. Also, as a preliminary matter, I want you to think about what's in your estate. If you're a single individual, your estate is pretty much everything you own. Whether you have a partial interest, a full interest, everything that's in your name that you have some sort of ownership interest in. If you're part of a married couple, That's where things can get a little bit more complicated. So if you're married, your estate includes all of your separate property. So anything that you owned prior to marriage, anything that you've personally been gifted or inherited, as long as you haven't commingled that with your spouse. And then you can gift away at your death half of the community property that you own jointly with your spouse. So if you've been married for a long time, you've probably accumulated a lot of community property. So when I talk about estate planning, I mean, how are we going to dispose or transfer of these assets in your estate? I also like to talk about the different kinds of assets. So split that off into two categories. You may have probate assets, which means those are things that you own that you haven't already designated a pay-on-death beneficiary. That's different from non-probate assets that are going to transfer automatically because you've already designated a pay-on-death owner. So think about a 401k or certain retirement benefits. When you set it up, you probably had to designate a pay-on-death beneficiary. That's an asset that's going to transfer automatically. It's not going to be covered by your will in most circumstances. So lots of different kinds of non-probate assets out there. You may own real estate or a bank account that's designated joint tenants with right of survivorship. You may have a pay-on-death beneficiary on a bank account. Lots of different ways that we can hold assets that would qualify them as non-probate. And the benefit of having a non-probate asset is that the beneficiary, the person that's going to receive that at your death, doesn't have to go through the probate process or administer your estate, with court oversight. So I'll be talking about that a little bit more as well. Probate tends to get a bad rap, and it can be a really difficult process in some states. I will tell you, I've been doing probate in Washington for nearly 10 years. We have a pretty good system. So if you own property only in Washington state, probate isn't going to be, or shouldn't be, too bad of a process. If you own real estate in other states, then there are some estate planning tools that may be helpful so that you can avoid probate in the future. But generally, probate is just a process where the court provides some degree of oversight to administer your estate at death. So the court's going to appoint a personal representative, also called an executor, and that person is the one with the responsibility to carry out your affairs, make sure any final bills are paid, and then distribute your assets according to your wishes. So you get to pick who you want your personal representative to be when you're doing estate planning and put something like a will in place. So with that said, I want to now transition into some different estate planning tools. Some help you avoid probate. Some of them can help make probate go a lot more smoothly. So one thing that I hear a lot of kind of misinformation about is community property. Washington is a community property state, which essentially means everything you accumulate or earn during marriage fits into this classification as community property that you co-own with your spouse. Well, a community property agreement, or sometimes called a community property survivorship agreement or a spousal property agreement, simply is an agreement between spouses that says everything I own, I'm going to consider community property. And when I pass away, it automatically transfers to my spouse. So it can be a really helpful estate planning instrument so that when one spouse passes away, the surviving spouse doesn't have to necessarily go through probate, and it's an easy way to transition those assets out of joint community ownership into the name of the surviving spouse. It's a really helpful tool for spouses that have been married, particularly for a long time, and to really simplify the process when one spouse passes away. It doesn't alleviate the need for bigger estate planning, though, because if something happens to both spouses, that's when a will would kick in. So it's important to have a will or other estate planning documents in addition to a community property agreement. Probably the most common estate planning tool that you're aware of, that most people have, is a last will. So at the very basic level in Washington state, any person of sound mind who's a legal adult, 18 years or older, can make a will. It does have to be in writing, so no kind of shouting what you want on your deathbed. It has to be signed and dated by you. Needs to be witnessed. Your signature needs to be witnessed by 2 disinterested witnesses. So people who are not necessarily going to inherit under that will. And then ideally, it's a self-proving will, which means when you do pass away, if the will has to be admitted to probate, we don't have to go track down those witnesses and get testimony from them that says they remember you signing the will, you weren't under duress. They've already signed off on a sworn statement to that effect. Most commonly, wills will have kind of basic content. You'll see wills will identify who you are and your immediate family. Even if you're not gifting to any family members, it can be really helpful that you list who your immediate family is, because that's one way to prove that you have testamentary capacity, that you understand who your immediate family is, and you understand what you're doing with a will. It can be important to make sure that you revoke any prior wills or codicils, which are amendments to a will that you've done. And then in Washington, oftentimes you're going to see a paragraph about personal property. So what's really nice about Washington is we have this statute that essentially says if you reference in your will or trust that you may keep a separate writing gifting tangible personal property, then that's essentially incorporated into your will. So this is where, you know, my grandmother, when I was younger, went to her daughters and said, okay, you each have different color Post-it notes and put them on the things in the house that you want. It's a lot more formal process than that, but it's a way that someone who's making a will can constantly add to and amend, add to, change a list of who they want to get specific items. You can update that list without having to update your will. So that's a common paragraph you may see in estate planning documents. And then from there, you identify who do you want to get the things, the wealth that you've accumulated. You can have specific bequests, which are gifts of certain things to certain people or certain dollar amounts. Or you can have a residuary clause, which says everything I have goes to this person or this group of people in equal shares. You'll also see in typical will or a good will that you've actually nominated a personal representative or an executor. Who do you trust to carry out your wishes in that will? It can be a family member, it can be someone who is a beneficiary under your will, but it's important to name not only one person, but backups, right? If your first person that you name is unable or unwilling to act, you want to choose who the backup is instead of a court choosing for you. You'll also commonly see in that personal representative paragraph reference to non-intervention powers or bond. So that simply means that if someone is appointed to act as personal representative with the non-intervention powers, that they don't have to keep going back to the court to ask for permission to settle your affairs. They have kind of the ability, the authority to settle everything without having to keep checking in with the court. And the important thing with a will is the signature of the testator. That's the person making the will. It does need to be on there and it does need to be witnessed. I've had a few family members reach out and say my parent passed away. They didn't actually sign the will, but they had a draft in their email. Doesn't count. Has to be signed, and that signature needs to be witnessed by 2 witnesses who also sign the will. So from there, that's kind of the basic content. But the good thing about a will is that you can tailor it to your particular needs, your wishes, your concerns for your family, your loved ones, and your priorities. So if you are a parent of a minor child, you probably want to consider adding a reference to a guardian for your children. Right? If you're not there to care for them, you or their other parent, who do you want to be in kind of responsible for them, to help them have custody of them in your absence? And then we also see in some wills, kind of more complex, we start to look at trusts, right? Maybe you want to gift to someone, but you don't want to give them the money outright. So a trust can be really tailored for the particular beneficiary. Sometimes we add trusts for tax purposes, as I'll talk about, avoiding some estate taxes. Maybe it's because we want to provide for a minor, or if you're like me, I'm a little bit of a crazy dog lady. I can set aside money for the care of my pets. There are a lot of different ways that we can tailor trust to particular needs. So with that said, I am just going to kind of touch the very, very surface of trust, because there are so many and they can be really tailored to your particular needs. Trust can be a separate estate planning tool, or they can be part of your will. So sometimes you'll hear about revocable living trusts. Those are trusts that are created during your lifetime, funded with some sort of asset while you are alive, versus a testamentary trust, which only comes into existence after you've passed away. Regardless of the type of trust or when it's created or funded, a trust is just an arrangement that allows a third party, a trustee, to hold assets for the benefit of another person. So in this scenario, if I'm doing estate planning for myself and I want to provide for my dog Zeke, who's the love of my life, I'm the settler, right? And I can transfer property, maybe $1,000, into a trust for his benefit. So if I'm not here, I can designate a trustee, another person, who's going to hold on to those funds and manage them for his benefit, right? Maybe it's paying vet bills, buying food, things like that. The beneficiary and the trustee need different people, so that maybe you have a minor or maybe an irresponsible beneficiary, that they're not in charge of that inheritance. You've identified someone you trust to manage that for you. So trust can be a really helpful estate planning tool if you are gifting to a child or grandchild who is a minor, who can't kind of own property until they're at least 18. There are other tools for gifting to minors. One is called a Uniform Transfers to Minor Act account. So sometimes you see those in estate planning tools. You can use a trust if you want to give to someone who is maybe incapacitated, not financially responsible. Maybe they're receiving needs-based government benefits and you don't want that inheritance to disqualify them. Maybe you want to gift to someone who has a lot of creditors knocking on their door. So there's a lot of ways that a trust can be beneficial. If you've ever watched Susie Orman, she is really big on trusts and revocable living trusts. Again, it makes sense in some states. It doesn't always make sense to have a trust, particularly in Washington, if you plan to stay here or you don't plan to buy property in other states. So when it comes to setting up a trust, there are so many different options. It's really important to talk to someone like an estate planning attorney to figure out if your particular scenario makes a trust reasonable or appropriate. I will say with that caveat, sometimes I do recommend revocable living trusts if a client really wants to avoid probate and they put all of their assets into that trust, or if they own property in several different states and they don't want probate to have to be opened in every state. And sometimes if you have a blended family, right? So if You and your spouse, maybe it's a second marriage, you both have children from prior relationships. How can you jointly agree to hold those assets for the benefit of both of your families? So again, whether you want to trust or not, whether it's appropriate, really dependent on the circumstances. So with that said, death and taxes, right, are the only things guaranteed in life. I do want to briefly touch on estate taxes. So I have some clients who call and say, I want to make sure that the government doesn't get a dime when I pass away. So sometimes you hear estate taxes or succession taxes or death taxes. The good news is that estate taxes don't kick in until you're over, or your estate is over the exemption amount. So it can change every year, but in Washington for the year 2020, estates are not taxed if they are below 2.193 million. At the federal level, estates aren't taxed if they're below 11.58 million. So, you know, with the price of real estate these days, the value, you may have more than that exemption amount in your estate, and you may want to think about, are there ways that I can avoid estate taxes? Also, a good thing is that any gifts to your spouse, even if they're over that $2.193 million threshold, those are exempt. Gifts to charities and political organizations, those are exempt as well. So there are ways that we can avoid or address estate taxes if that becomes an issue. Okay, so I guess before I jump into planning for incapacity or disability, I don't know if there are any questions that I should take. I don't know that I've seen any.
No questions quite yet have come through the chat.
Perfect. Okay, well then I will keep rolling. So the next category of planning is really planning for periods where you're alive, but maybe you're not able to really direct your own care, direct the own management of your finances. So it's planning in advance for periods where you may be incapacitated, whether it's permanent or temporary, where you may not be able to act for yourself. How do you put your wishes in place now so that if an emergency does arise, it's going to be easy for your loved ones, for the people involved, to kind of seamlessly take over and hopefully manage those assets or those decisions for you. So it's important to keep in mind that a will only has legal effect when the maker's passed away. So just because you've designated someone your executor, your personal representative under your will, it doesn't give them any authority while you're alive. So that's why a power of attorney is a really helpful tool to cover that gap, maybe between when you start to lose capacity to manage things on your own, but while you're still alive. So really important tool that maybe people don't necessarily think about. It can be applicable if there's a temporary period of incapacity. Usually when you go into the hospital for a medical procedure, right, they're going to ask at intake, do you have a power of attorney, or who should we talk to if you can't make your own decisions? And maybe more permanent or debilitating kind of issues of Alzheimer's, and you start to lose maybe your ability to manage your own affairs day to day. So powers of attorney can be super helpful in those periods and really make it clear to family members, to third parties, who has the authority to act in your place.
Elizabeth, we have a question. What are good options for leaving assets if the surviving children or grandchildren are not responsible and would not be able to manage the assets properly?
Good question. So that's where I would say a trust may be a really good structure, especially if it doesn't have to be that they're minors, but I like to think I'm the most responsible of my parents' children. I have a brother that for many, many years until he hit 40, probably wouldn't be terribly responsible. And so what makes sense is maybe you can set up a trust structure so that that person who maybe is irresponsible They aren't getting a huge influx of cash or inheritance, but you can work into that trust structure that maybe they get funds at certain benchmarks, certain ages. Often when they graduate from college, or at age 25, and then a chunk at age 30. You can also write a trust so that your trustee has a lot of discretion, right? That they can pay for things in an emergency, or they can help that beneficiary with a down payment on a home. So that's where it's really important when you're thinking about who you want to provide for. Also thinking about, are you okay with them getting those funds automatically? Or do you want to put some strings on it, or maybe designate someone else to manage those assets for them, or make decisions about what's appropriate spending from those assets? I hope that addressed your question. So when it comes to powers of attorney, it's just a document. Some are super short, 1 or 2 pages. Some are really long and detailed. But it's an agreement or a legal document where you are identifying an agent. You're creating a relationship where you are saying, I, as the principal, am going to give this person the authority to act on my behalf. So your agent, or your attorney in fact, or your power of attorney, however they're labeled, that person gets to stand in your shoes and manage your finances, manage your decisions, manage your life to the extent that you give them that authority. It can also be used for a limited purpose or a limited duration. So I actually had a client at the beginning of this year, husband and wife, they were in the process of selling their home, listing it for sale, and the husband actually had to go travel abroad to go care for a family member. And so we did a limited power of attorney that gave his wife the ability to sign all of the real estate documents on his behalf, since he was going to be abroad. Well, then COVID happened, and he was stuck abroad months longer than anticipated. But because of that limited power of attorney, his wife was able to go through the process and get everything finalized, even though he wasn't physically there. So there are lots of different ways that we can tailor a power of attorney to your particular needs and your comfort level. Powers of attorney are provided for by Washington statute. And so you can go check out the revised Code of Washington. There's kind of a long list of default powers that you're giving an agent under a power of attorney, but you can always modify that as part of the document itself. I get this question a lot, kind of, who do I name as my agent or my power of attorney? It can be a family member. It can be your spouse. It can be children. It can be more than one person at a time. If there's not a friend or family member that you trust, there are also professional fiduciary companies that you can name, that their job is to kind of step in if need be. So lots of different options. I just always advise clients, think about who you would trust to stand in your shoes, and also think about alternates. If that first person you name isn't able to act when you need them to, is there a backup or a second backup that you're comfortable with?
Elizabeth, we have one more question that came in, and the question is there a difference of a POD versus a TOD, and can a bank do that setup and then no one else sees it at death?
So I think you're asking about like a pay on death or a transfer on death bank account designation. Yes, so that is a common way when you set up a bank account, or even after you've set out a bank account, you can go to your bank and say, I want to designate a pay on death or a transfer on death beneficiary. They are usually the same thing. They function the same way. But it's a way that you designate a person to get that bank account automatically without it being covered by your will. So that is a really good tool if you don't want everyone out there to know that asset or who got it. So yes, it's a great estate planning tool. There are some ways that the personal representative of your estate may be able to get information about that transfer on death account, especially if the assets in your estate are insufficient to pay, final taxes or bills. But generally, that's a really nice way to transfer assets without it being kind of known to the public or subject to your probate estate. It's a good question. Those are helpful tools. If it's been a few years or a few decades since you set up your bank accounts, it's worth reaching out to the financial institution and seeing, do you have a pay on death beneficiary? If not, or if it's someone you don't want to name anymore, good time to update that with the financial institution. So when it comes to powers of attorney, you'll see two types. Some powers of attorney are effective immediately. So they essentially say, as soon as I sign this document, my designated agent has authority to act. So that means that if you are competent and fine, your designated agent has the ability to act with you. Or maybe they're just sitting in the wings and they're looking out, making sure that you're okay and you don't need that assistance. I usually recommend that you make your power of attorney effective immediately as to your spouse, a really trusted individual, or if you anticipate maybe issues down the road. Because the other option is that you have a springing power of attorney, which means that your agent only has authority to act if a physician has put in writing that you are unable to manage your own affairs or that you're incapacitated. So in an emergency, sometimes it can take a little bit of time and administrative hoops to jump through before you can trigger that power of attorney. So that's one big question I ask clients to think about. Are you comfortable naming someone to act immediately, or do you feel more comfortable making it only effective if you are deemed incapacitated?
Elizabeth, we have another question that's come through, and the question is it harder to contest? Is it harder to contest versus a will? Is a trust harder to contest versus a will?
Good question. They're both not easy to contest. The benefit of a trust is that the pool of people kind of with ability to get information about the trust can be limited. Versus a will, it's part of public record when it's submitted to probate. However, the legal standard to contest a will or contest a trust is the same. So I would say neither one is necessarily easy to contest. But if you're concerned about maybe a family member or someone that you don't want to receive anything contesting your documents, sometimes sometimes a trust can be a better option because they're not automatically entitled to notice, versus with probate, your heirs at law, the people that would inherit if you didn't have a will, are entitled to notice when probate's open. So a trust can be a better way to kind of protect what's happening with your estate, but both a will and a trust can be contested. So lots of good questions. Feel free to jump in as you go. Powers of attorney, I just want to keep in mind, it does have to be in writing, and your signature on it needs to be notarized or done in front of 2 witnesses. I generally recommend that having your signature notarized is the best option, because if that power of attorney ever has to be used to buy or sell real estate, title companies are going to want to see that that document was notarized. Again, lots of default authority that can be granted in a power of attorney by statute, but there are also optional powers, kind of extraordinary powers that you can give your agent. So sometimes you want to give your designated agent the authority to make gifts out of your assets while you are alive, right? So if you have a pattern of every year gifting to a particular charity and you want your agent to continue that pattern of gifting, you can work that into your power of attorney. Maybe someone doesn't want to go through the hassle of updating beneficiary designations on bank accounts. You can give your agent that authority to do so. So these are kind of extra powers that have to be specifically listed in your power of attorney in order for your designated agent to have that authority. So sometimes you see powers of attorney that are one big document that cover finances and healthcare. Most of the time, I tend to do two separate documents. One related to finances or property, and one related to healthcare or medical decisions. Because personally, there are some people that I would trust to manage my property, but I don't necessarily want them to make healthcare decisions for me. Maybe we don't quite align on that. So you can name different people as your agent under a separate financial versus a separate medical power of attorney. A financial or property power of attorney gives your agent the ability to manage your finances. So pay bills out of your bank account, buy and sell property, particularly if maybe a house needs to be sold to pay for your care. They also have a responsibility to coordinate with your healthcare agent to make sure that your bills and your medical expenses are getting paid. So that's a little bit different than a healthcare power of attorney. So a healthcare power of attorney really only kicks in if your medical provider, like your physician, finds that you are not able to understand and give informed consent for medical procedures or decisions. So a medical or healthcare power of attorney is designating someone with the authority to act, to give informed consent and make decisions about your care if you're unable to make those decisions yourself or unable to really appreciate or understand the implications of these decisions. If you don't have a healthcare power of attorney, there is a statute in Washington that has kind of a hierarchy of who can give informed consent on your behalf. So it's usually a spouse, adult children, kind of goes out your family tree. So if you want to depart from that kind of default list, really important to have a healthcare power of attorney. For finances, there is no default list of who has authority to act. So that's why it's really important to have a power of attorney to manage your finances or property issues if you're unable to act on your own.
Elizabeth, we have another question that's come in, and the question is, can an individual have a will in the United States and a foreign country at the same time? For example, one has a bank account or property in a foreign country.
Ooh, good question. It depends on the country, but generally you can make a will that only disposes of a particular asset. So I usually advise clients, make a will that covers everything you own, but you could also have a separate will that just addresses a particular item. You would just want to make sure that those two wills are not in conflict or one doesn't revoke the other. And again, if you have property in a different country, I highly recommend consulting with an attorney, someone in that country who knows the particular process. Some countries are easier than others when there's real estate there that needs to be probated or administered. So proceed with caution, consult with professionals. That's probably going to alleviate headaches down the road. So kind of our next area, if we're planning for periods of incapacity or disability, it's known by a lot of different names. So living will was common for a while. More broadly, advanced directives or medical or healthcare directives. These are documents where you identify and express your wishes for end-of-life care. So some are really broad and can address your wishes in a lot of different scenarios. By statute in Washington, the big decisions that you can make are, do you want artificial hydration and nutrition? Do you want to be on a respirator? Do you want pain medication? And these advanced directives usually are only triggered If you are deemed kind of in a permanent unconscious condition, in a coma, with a terminal illness, and your loved ones or physician can't talk to you about what your wishes are. So an advance directive is a way that you can express those wishes in writing in a way that your medical providers and family members need to honor.
Elizabeth, we have a question, and it states, if 911 is called and they take you to the hospital alive, if possible, ignoring your advance directives or pulsed.
Ooh, then that's a possible malpractice claim. So good mention of pulsed. So a pulsed form, usually you see those are like a bright green, and they may be on your fridge or right by your front door. That's a form that you would complete with your physician, and it's noticed to emergency personnel, 911, if an ambulance shows up, kind of what kind of emergency life-saving measures do you want or not want. Medical providers, emergency personnel are supposed to honor that, and they may be exposed to liability if they don't. So that's where I would say, and one of the big pieces of advice I want to impart is that the more you plan and the more you advise your loved ones what your wishes are, that is hopefully going to alleviate some of the conflict down the road. But unfortunately, it happens every once in a while that maybe emergency personnel don't see the pulse, don't check your medical records, or maybe just aren't following them, and that usually doesn't end up well for anyone, unfortunately. So before we transition to the fun part of our discussion, keep those questions coming, really good questions, and a lot of really complex and difficult issues, but good things to think about. So the last kind of segment I like to talk about is planning to live a long time, right? That's great, live a long, full life, but unfortunately we have to think about how do we financially plan for that. And I speak with a lot of clients that their priority may be to remain in their home as long as possible, or maybe they want to make sure that they're financially set up to move somewhere where they're comfortable, that has all the services they need. And so a big part of my working with clients is not only talking about their legal wishes, but also talking about financial planning and planning for long-term care. So if you consult with an attorney, reach out to them about estate planning, they may say, okay, here's the information I need, or send you a questionnaire and you may start filling it out. And you're like, oh my gosh, they're asking me about my property and my bank accounts and my assets. It may seem intrusive, but all of this information is really helpful to look at what kind of legal documents can we put in place. And financially, how are we going to provide for your care or your retirement in the long term? So don't be shocked if you are working with an experienced estate planning attorney and they start to ask you questions about your finances. So a lot of times there's thinking to be done before you jump into estate planning or as part of the process. So not only thinking through what are your assets, what do you own, what's your health status, your last checkup, everything's fine, or do you have any maybe chronic illnesses or diagnoses that your attorney may want to know about? And then do you have an idea of your future needs or costs, right? What is the income that you can expect going forward? And what are your wishes for your long-term residency or care? If someone has a diagnosis that seems like it may lead to intensive nursing home care, that can be an expensive process versus someone that wants to transition to an assisted living place or have in-home care. There are different tools that we can use to help pay for those expenses. I get a lot of clients that say, doesn't Medicare cover everything? No, unfortunately for things like placement in an adult family home, assisted living community, Medicare is not going to cover everything. So it's important to look at your finances and what are your priorities. Sometimes that's providing for loved ones. Maybe it's making sure that you're somewhere you want to be and you're comfortable and you're able to get the assistance that you need. Especially for a nursing home care, when you really need intensive kind of medical supervision, the expenses can start to add up. It can be a pretty expensive process. And you also have to think about, if a loved one has increased care needs, a particular diagnosis, sometimes the cost can go up from there. So it can be expensive to pay for long-term care, especially if you're not planning well in advance. So a lot of times I'm talking to clients about, what are the assets in your savings? What kind of retirement benefits do you have? What are your Social Security income? Sometimes I'm talking to clients about long-term care insurance. So some insurance carriers provide this as a financial tool that you can tap into certain benefits if you have certain long-term care needs. And then I also get a lot of questions about Medicaid. So we hear a lot in the news about Medicaid and Medicare. Medicaid is a government assistance program that will cover some costs or can cover all costs for long-term care, but you have to qualify both by your medical needs or your activities of daily living that you need assistance with, but also financial qualifications. So financially, have you spent down your assets to a level that you can no longer pay for your own care? Maybe you qualify for this additional government benefit. So Medicaid can be a really helpful tool, but it requires usually a lot of planning. So I have some people that come to me and they say, Mom needs to qualify for Medicaid, so we transferred her house to my brother and all of her bank accounts into my name, and on paper it looks like she doesn't own anything, so she's going to qualify for Medicaid. That doesn't always happen. So Medicaid has a 5-year look-back period. It used to be 3 years. Now they've pushed it out to 5 years. But they're going to see, did the person applying for this coverage, did they gift away their assets? Did they sell or transfer property for less than fair market value? That can result in a penalty period in which that person is not able to qualify for Medicaid. So we do a lot of Medicaid planning as part of our estate planning, particularly for couples, because Medicaid does look at what are the assets that both individuals in a couple own or have accessible to them, and that can help someone qualify or not qualify for Medicaid. So there are estate planning tools, financial strategies that can be put in place to help one spouse qualify for Medicaid if they need, and try to maximize the assets available to that kind of healthier spouse. So Medicaid planning could be a tricky and complex area. It's one I highly recommend that you do consult with an attorney who is experienced in Medicaid to help you navigate that process. And common theme here is planning, and planning early usually helps alleviate issues. So I highly recommend, don't wait to the last minute or, till you think someone's going to need to qualify for Medicaid. Start that conversation sooner rather than later and start to put a plan in place. So I realize I just kind of blew through a whole bunch of topics and there's a lot of stuff out there. My big pieces of advice to alleviate issues down the road, conflict with family members, plan in advance and have these conversations with your loved ones. Make it clear to them what your wishes are, whether it be wishes for long-term care placement, wishes for who you want to manage your affairs if you're unable to, and what are your wishes for your estate in the long term, right? It's where there are surprises that we didn't know that, mom wanted to give everything to the poodle, not to her children. that sometimes raises issues down the road. So as transparent as you can be with your loved ones, I found that tends to make things go a lot more smoothly at the end of the day.
Thank you, Elizabeth. We really appreciate your time today and the information that you provided. I think it's really vital information for everybody. I'm just going to take a quick minute and pause and give anybody else an opportunity to throw a question into the chat if they have one. So I'm just going to kind of be quiet and just wait for just another moment to see if any other questions come through.
Sounds good.
Okay, it doesn't look like we're getting any more questions coming through. So with that, I'm going to go ahead and wrap things up from the Gardens at Town Square. Again, thank you all for joining us today. If you or a loved one are interested in learning more about the Gardens at Town Square, we would absolutely love to hear from you. My email address one more time is andrew.harris@eraliving.com, and I'll be able to get those for you. Oops, looks like we had one question sneak in right there at the very end of that, so I'll read that real quick. If you have an updated will, is it important to destroy the one that supersedes it?
Yes. So if you are replacing your will and you decide to revoke or kind of destroy your past will, yes. The original will is the big thing. So if you now have a new original will, you can shred, you can tear up, you can burn your older will. And that can be helpful so that there's not a conflict down the road. But usually your new will say expressly that you revoke all prior wills or codicils. So that's another way to effectively revoke a will. But if no one can find the old will, that helps as well.
Perfect. Thank you again, Elizabeth, for your time. We appreciate it. We appreciate everybody that joined us today. Thank you all. Stay safe, and we'll see you next time.